just start. Thank you for your interest at this early hour. I welcome you to a panel on advertisement intelligence by European security agencies. My name is Thorsten Wetzling, and I'm honored to moderate this session that deals with a topic that I find complex, fascinating, daunting, overwhelming, scary, and very timely. It certainly also needs a lot more skillful unpacking, and I'm thrilled that 4 excellent speakers will help us shed different light on a mode of government access to data that deserves closer scrutiny. Please welcome Sharon Bradford Franklin, who was until January this year the chair of the US Privacy and Civil Liberties Oversight Board in Washington, whose mission is to ensure that the federal government's efforts to prevent terrorism are balanced with the need to protect privacy and civil liberties. Not so balanced is the current composition of that board. 3 members were forced to resign in January, including Sharon. But thank you so much for being here. You found your way. Jan, over to you. It's a real pleasure to have you here this morning with us. He brings a perspective that is in high demand. Jan works as senior specialist at Europol's Data Protection Unit. And I'm very glad that you accepted this invitation at this red-eye invitation, shall we say. No stranger to The Hague is Judith Lichtenberg. Judith is a member of the Dutch Review Committee on the Intelligence and Security Services, CTIVD. One intelligence oversight body, that much I can say, whose reports I find very, very insightful, and they are made available in English, for which I, for one, am truly grateful. Good morning to you, Judith. And over, last but no means least, Corvinian Rockerbauer, my dear colleague, senior researcher at Interface, a think tank, and you focus on intelligence oversight, public-private co-production of security and its impact on fundamental rights and our democracies. Great to have you here as well this morning. Now, commercial surveillance, data brokerage are topics that attract significant attention, not just at nerdfests here in Brussels, but also, and the booming data market offers many services and tailor-made solutions for national security agencies, law enforcement, and defense agencies, or the security sector writ large. They have a vested interest in acquiring or accessing data on the data market. For further context, Corvinian, please show just a general cursory illustration of what. This is Jan's presentation, so we need to give you a little bit of a foreshadowing. Do you have ours?
Doesn't react. Oh, we need to go to the very start.
Oh, yes.
Yeah.
One. Next one.
Okay.
And one more.
So, all right. Thanks.
Thank you so much. So as you can see, these are just some products that one may find at the booming data market. Services can purchase data, data acquisition through the participation in real-time bidding on the data market. They can purchase static data sets. They can subscribe to dynamic data sets. Some of you have heard about a broker, even in Berlin. Some people were able to acquire 3.6 billion geolocation data for a modest sum of 13,000 euro recently. There's a purchase. You can also purchase licenses for software solutions with integrated data sets. And of course, you can also acquire finished intelligence. And it's far more complex. Just a few recent illustrations of data broker security sector contracts from the United States. These are taken from a joint comment of US civil liberty, civil society organizations. For instance, the US Immigration and Enforcement Agency, ICE, has spent over $2.8 billion US dollars on data broker services from 2008 to 2021. The FBI paid ZeroFox $14 million just for its protest monitoring service of a service called ZeroFox. And just recently, in an explanatory text to the amendment of Germany's legal framework for intelligence collection, it is acknowledged that special databases are being used, which, I quote, which may include offers subject to payment. And this may imply data transfers from the purchase of extensive advertising databases, end of quote. And there are a lot of terms for this you can find in the literature. So we chose commercially sourced data or advertisement intelligence, ad-int. In the US, the government likes to speak of commercially available information, CAI. Think tanks refer to it as data broker purchasing, or purchasing data from data brokers. And it's very broad. The US Department of Defense has a term, it's called collateral telemetry data, which includes data sets from advertisement technologies, real-time bidding, software development kits, and telematics under US government control. Of course, all of this can be tied to a term that some of you may be more familiar with. It's called publicly available data. But we will discuss with our audience and with our guests here whether this common term and the standards for data collection for national security purposes are adequate still, given the uniqueness of data purchases. And it's now high time for me to turn to each speaker who has been given 10 minutes. And over to you, Corbinian, first for current research that you do that compares different approaches to regulation and oversight. The floor is yours.
Thank you so much. So happy to share a little bit some insights on our current research on this topic. And to start with, I just showed you the cover page of a report that we've put out in 2022 already on the topic. Don't be confused, this is the old name of our organization. That was still a German name, and now we're called Interface and not Stiftung Neue Verantwortung anymore, but it's the same organization. In this publication, we explored the interactions between intelligence services and private companies. And since 2022, some countries have made significant progress on this, and there are first promising approaches to actually close the gaps in oversight and in the legal frameworks. However, in many countries also nothing has happened, and so we still see the need to have a closer look to this. And because especially at the same time, as Thorsten just mentioned, more and more cases become public where we actually see that the data broker industry just keeps getting bigger and the access of security agencies is also growing. So this year, therefore, we wanted to take a closer look on which problems actually persist and create knowledge on good practices, so to identify some solutions for this problem and thus contribute to the debate that is taking place. So our guiding question in this was how to ensure that intelligence services can work effectively, of course, and at the same time be prevented from unconstrained and disproportionate access to personal data by using these kind of commercially sourced data. So for this, we think it's necessary that the legislator need to close the loopholes in regulation, and second, or B, if I start with an A, that oversight bodies are enabled to ensure end-to-end oversight. And for doing so, these oversight bodies actually need to have a complete picture on the work of intelligence services within their oversight mandate. So what do they actually do, and also to have a full picture on the use of commercially sourced data. And yes, in our research this year, we want to take a closer look to how the status quo is. And I would like to share some preliminary findings of this research with you. And so we have recently written a discussion paper where we further investigated on the topic. And yeah, in this research we have identified a number of risks that I would like to share with you, but also we took a close look at what I just mentioned, the status quo in different countries. So we made case studies of 3 different states, and yeah, we're analyzing the regulation and oversight in place. Just that you get an understanding of what our angle was, I just put you 2 central questions of the publication on the slides here. There was I think it is important to understand that it's a twofold challenge that we're facing here. It's the legal framework that needs to be designed appropriately. So our question for this was, what key safeguards does the national legal framework currently prescribe regarding the access, use, transfer, and the deletion of commercially sourced data by intelligence agencies and private sector entities working on their behalf? And also, what does it omit? So what is actually not regulated in this legal framework? And the second aspect, or the second dimension, is, as I mentioned, the remit and the capacities of the oversight bodies that are supposed to oversee this. So therefore, the second question was, does the formal remit of national oversight bodies include the review of access and use of commercially sourced data by intelligence services? And is there publicly available knowledge on the oversight activities? Maybe as a little caveat, not all insufficiencies that I will share with you now are actually applied to all the countries that we have analyzed. And also our research is still work in progress, but we wanted to use the opportunity to share these first findings with you. Yeah, so I limited myself to just 5 of the insufficiencies that we identified. And to start with the first, it is the lacking independent authorization for severe interferences with fundamental rights. So when we look at other collection means like signals intelligence, for example, there in many cases for acquiring particularly sensitive personal data, you need to get an ex-ante authorization by an independent body outside of the executive branch. If the data is purchased, though, and that can relate to similarly sensitive data, this is the absolute exception. So this only exists in very few countries, actually, that you need to get an independent authorization for these kind of transactions. And here we see a major risk of actually circumventing such safeguards by just choosing another mode of access. The second problem that we have identified is that many times oversight bodies just don't have the full picture of ongoing surveillance, so of all the surveillance practices that are executed. One problem of this is that or many oversight bodies just have a quite fragmented oversight mandate and can't access every database and every database that an intelligence services can access, and this problem is particularly important when these databases are held by private companies, because oftentimes oversight bodies just don't have the possibility to, for example, force a private company to grant access to their systems. And so therefore many oversight bodies just don't have the impression that they are aware of all the data transactions between the agencies and companies. And the risk of this, of course, is that if there is not a complete picture of what is actually happening, that sometimes it can just depend on incidental findings whether misconduct is actually discovered or not. Then the third risk I would like to address is that oversight bodies, and we're wondering in some cases as well, we have doubt whether intelligence services are actually able to do it, that oversight bodies are unable to evaluate the acquired data to a sufficient extent. The evaluation of the data that is collected by the intelligence services is a very important aspect, since the evaluation of the proportionality of collecting data is, to do this, it's key to actually understand what exactly the data contains, which and how many individuals are concerned, under what circumstances the data was actually collected, and also whether the quality of the data is sufficient. So this all actually has impacts on the lawfulness of data collection. And in this context, when we talk about purchase data, we have severe doubts that this is actually these information are actually accessible to the oversight bodies. Then I will make it very short for the fourth point. Here we also have the problem that oversight bodies don't have enough knowledge on how the data is processed, especially when private sector tools are used to process the data. Oftentimes it's just hard to access the algorithms or understand how exactly this works. And so here we actually have a double black box. So first, you don't really, in some cases, understand what exactly the data is and what features it has got. And then you process this with some tools that you don't fully understand either. And that makes it extremely difficult to actually tell whether this is a lawful practice or not. I will skip the fifth point because I wanted to share some positive things as well. So I will turn to the good practices that we have identified, and especially because the fifth point, we will come to this later in the following statements. So the good practices that we saw and that we found promising approaches to actually step into this now oftentimes under-regulated field is some oversight bodies have a holistic oversight mandate. That means they can, many activities of security agencies are included, and for example, the Norwegian oversight body can actually follow the data wherever it comes from. So that also means they can also go to private companies and enforce the access to this data, which we found very important to address the issues that I just mentioned. And some oversight bodies are informed about any new bulk data set that's integrated into the IT systems, regardless of how it was acquired. Then we also see extensive reporting on this specific problems, for example, in the Netherlands. And we also see, as a promising approach, regulatory frameworks that determine the applicable safeguards according to the sensitivity of the data, and not only the method, which prevents the circumvention of safeguards by just choosing other means of collection. And on this positive note, I would like to end.
Good. I just happened to show you this 1 minute. Thank you so much, Corbinian, for that. I now turn over to Sharon for a perspective on the state of play in the United States, which has a very rich ad tech industry, and I'm curious what you have to report. Thank you, Sharon.
Thank you. And thank you for the opportunity to participate today and to present a view from the United States. I just want to start by noting that with regard to the Privacy and Civil Liberties Oversight Board, where I previously served. My term was coming to an end at the end of January anyway. I was terminated 2 days before, but I'm happy to report that my two colleagues who filed a lawsuit just yesterday, the district judge in that case, found that those terminations were illegal, and as of last night, they were back. My two colleagues are back on the website. I'm sure there will be an appeal, but a good development. So I want to. My perspective comes not only from my role as a former oversight official, but also I'm somebody who has gone back and forth between working in civil society and also in our U.S. government. So it's both a civil society perspective and an former oversight official perspective. And at the end of 2021, when I was in civil society, I was one of 4 co-authors of a report by the Center for Democracy and Technology examining the privacy risks from US government purchases of data from brokers. And that report is titled Legal Loopholes and Data for Dollars: How Law Enforcement and Intelligence Agencies Are Buying Your Data from Brokers. And in the report, we discussed how multiple US agencies were spending at that time upwards of tens of millions of dollars on multi-year contracts. And we examined many of the privacy risks stemming from those purchases. And in particular, we discussed how there is a loophole in the US law called the Electronic Communications Privacy Act that allows government agencies to purchase data directly from brokers and evade otherwise applicable laws that would require legal process before they could acquire that data directly from the service providers. We also discussed how, in our view, these purchases can allow the government to evade constitutional requirements. In 2018, the US Supreme Court, in a case called Carpenter versus United States, held that the government must obtain a warrant before they can collect certain data that reveals the privacies of life. And we felt that other data, beside the data specifically at issue in the Carpenter case, is similarly revealing, and those protections really should extend in those contexts as well. And in that report, we made a number of recommendations, including that the US Congress should close that ECPA loophole. I've also been involved in these issues at the Privacy and Civil Liberties Oversight Board, where there is a project examining the FBI's use of open source information, including commercial data. Unfortunately, as at the time I left, that was still an open oversight project, so I can't share with you what will be in there or the state of the investigation to date. But I can flag, of course, that FBI is one of those US agencies that does purchase data from brokers. And in my view, because our FBI is both a law enforcement and an intelligence agency, it particularly raises concerns about the potential for an end run around otherwise applicable requirements for legal process before the government can acquire this data. Now, to date, the US Congress has not yet closed the loophole that permits law enforcement to buy data directly from brokers without any legal process. And in this regard, the US government has continued to oppose such legislation regarding its ability to purchase commercial data. And a key argument that they have made is US adversaries are able to buy this data directly from brokers, particularly China. And why then, they say, should we unilaterally tie the hands of our own government? Now, on the other hand, in the past couple of years, we have seen increasing recognition from US policymakers that data purchased directly from brokers can be different in scale and sensitivity from the general, what we have always referred to as publicly available information, due to such factors as the ability of brokers to aggregate vast quantities of data and the ability of brokers to collect information that is not otherwise easy to find and compile. So in my view, in the past few years, we have actually moved the ball forward in the US, though there is still much more work to be done. So we had a number of developments, particularly in 2024, and I want to focus in particular on, in May of 2024, the United States intelligence community, the Office of Director of National Intelligence, put out a document called the Intelligence Community Framework for Commercially Available Information. And so this is an internal executive branch policy, but it is currently in effect, and I want to flag 6 points that are contained in this framework that I think are salient. First, it defines sensitive commercially available information and provides a framework particularly for sensitive commercially available information. And it defines that category as data that meets one of 3 criteria. Either it contains a substantial volume of personally identifiable information, or PII, or it contains more than a minimal amount of sensitive data, which is data such as on things like race, political views, religious beliefs, or medical or financial information. And third, it can be data that captures sensitive activities that establish a pattern of life, so similar to that Carpenter decision that I mentioned. Second, the framework includes a section on access and collection, and it requires, in that regard, that privacy and civil liberties officials and legal counsel participate in the procurement process. It also requires an analysis to assess the totality of circumstances on whether it's appropriate to collect, including mission need, data sensitivity, privacy and civil liberties risks, the availability of privacy-enhancing technologies, data sourcing and integrity, and security risks. I also want to point out that in this section on access and collection, there's a specific requirement that IC elements shall limit their access to and collection and processing of such data to the maximum extent feasible, consistent with the mission need that they're trying to serve. Third point about the framework is that it actually includes a requirement that the IC element head must sign off on any decision to access or collect sensitive, commercially available information. A fourth point about the framework is that it requires policies and procedures for safeguarding, which includes a requirement for enhanced safeguards for sensitive, commercially available information. This section provides a list of the types of safeguards that IC elements can choose to implement to provide these enhanced safeguards. And these include things like restricting access to the data, procedures for auditing, and for requiring written justification for queries. A fifth point about the framework is that it requires reporting. It requires all of the individual IC elements to report to the Office of Director of National Intelligence, so centralized within the executive branch. It requires keeping Congress informed. And it also requires that every 2 years there be a public report. And I have been assured that they are on track to produce that. That will be due next spring in 2026. Finally, about this framework, I want to flag that in the definitions section, there are separate definitions of commercially available information and publicly available information. And this, I think, is critically important with regard to what Torsten said at the beginning. We have generally in this space seen governments, particularly the United States government, with rules that if it's publicly available, you've lost any privacy, the individuals have lost any privacy protections, they've put it out there. And now we have this recognition that there is publicly available information is one thing, and then commercially available information can be different. And this framework doesn't provide any particular rules for publicly available information, but the separate definition really does help clarify and reinforce that commercially available information requires more safeguards. And this policy is intended really as a layer on top of the otherwise applicable rules for the intelligence agencies, which are referred to as Attorney General guidelines or AG guidelines. And in most cases, those rules, those baseline rules, provide that if an intelligence community element has a valid mission purpose, they can collect publicly available information without further restrictions. But now with this commercially available information framework, that is no longer true for information that qualifies as CAI, and particularly if it is sensitive CAI. So overall, with this framework, I think we have definite improvements, particularly recognizing the category of sensitive CAI and the requirements for analysis of privacy risks, sign-off by component heads for purchase, and there are also requirements for documentation and reporting. However, there's still much more work to be done. This requirement for the IC component head to sign off is far from being the same thing as independent external review, the point that Corbinian made about the need for independent authorization. And it's also unclear how this policy, at this juncture, unclear how it's being implemented. Now, one data point we do have on this framework that could cut both ways is that last August, the Office of Director of National Intelligence issued a request for information, sort of like a contracting RFP, to create an IC data co-op. And they're seeking to build this data co-op to allow the intelligence community components to jointly purchase data, pool it, and access it. And a possible plus from this is maybe this will help them to coordinate to better vet the vendors and to ensure that the safeguards from the framework are being applied. But of course, a key risk from this kind of data co-op is that they really are seeking one-stop shopping to facilitate IC purchases of commercial data and pooling and sharing of that data. So I just want to quickly go through a couple of other developments we had in the US in 2024. We had two initiatives that addressed that threat I mentioned that the intelligence community has pointed to of US adversaries accessing the data from brokers. In February of 2024, we had Executive Order 14117 on preventing access to Americans' bulk sensitive personal data and US government-related data. And this requires restrictions on access to Americans' bulk sensitive data by countries of concern and creates a data security program for national security purposes. The Justice Department has put out implementing regulations, and that went into effect this spring, in this April. And just one point to flag is it doesn't only cover data brokers, it covers any company that has access to bulk personal data. We also had legislation enacted by Congress in April of 2024 called the Protecting Americans' Data from Foreign Adversaries Act, which only covers third-party data brokers, but it prohibits them from selling, licensing, or providing access to Americans' personal data. And then finally, I want to just mention that there is a law that has been proposed multiple times called the Fourth Amendment is Not for Sale Act, which is a wonderful title. And a year ago, last April, the US House of Representatives actually passed this act, although it did not pass both houses of Congress. And in my view, this is still needed. This is a bill that would actually close that ECPA loophole that I mentioned, so to actually have legislation prohibiting the government from doing this end run around the otherwise applicable legal requirements. And it would basically prohibit them from purchasing certain sensitive data from third-party sellers, including geolocation information, communications-related information, and information obtained through illegitimate scraping practices. But law enforcement would still be able to obtain this data using a warrant or court order or a subpoena. It's still a very salient issue in Congress, and I expect it will come up next year when our Congress has to consider a reauthorization of Section 702 of the Foreign Intelligence Surveillance Act. These have been linked in the past. And now that we have these two legal instruments I just mentioned, the Protecting Americans' Data from Foreign Adversaries Act, as well as an executive order on this topic with implementing regulations, both of which address this threat of foreign adversaries obtaining data from brokers. This really should help address the key IC objection to the Fourth Amendment is Not for Sale Act. Though when I say it should address that, I mean this as what I believe should happen rather than as a prediction of what will happen. So we'll have to see how this develops.
Thank you so much, Sharon, for this round overview of the state of play in the US. It's been fascinating to hear. Over to you, Jan, for I very much look forward to your slides as well and your perspective. There you go. From Europol's vantage point, I know some of those terms are used differently in Europe, and the floor is yours, Jan. Thank you so much.
Yeah, thank you very much also to my co-panelists. So my name is Jan Ellermann. I'm Senior Specialist in Europol's Data Protection Function. So my role here probably is to deliver a practitioner's viewpoint on this matter. When I was invited to speak on this panel, learning about advertisement intelligence, my first question to myself was, well, do we even do that? Because the term as such didn't ring a bell, to be very honest with you, in the first place. So at Europol, I think a lot of what we are discussing here would still run rather under the header of open source intelligence than advertisement intelligence. And also what Sharon just outlined, that there is a difference between what you consider OSINT and commercially sourced data. I would agree in terms of sensitivity, but still when we when we discuss matters, advertisement intelligence I've never heard before. So we discuss the same matters, but I think under the broader header of open source intelligence. And then, interestingly, our legal framework basically includes an Article 17, paragraph 2 of the Europol regulation, which says Europol may directly retrieve information, including personal data, from publicly available sources, including the internet and public data. And this is rather important because, of course, internet, everybody of us immediately has a view on what that entails. But then the discrepancy between public data and publicly available data, that is something which is interesting, because for lawyers it's all about in the details of the word. And the take we had on it, I'm gonna show you in a bit in more detail. But let me start maybe to expand a bit on where Europol as an organization even deals with publicly available data in the first place. Because also when we prepared, Torsten was asking me, are you guys using commercial intelligence providers at all? And I said, yes, we do. But maybe also to shed some light in which context it's useful to expand a bit. So Europol is the European law enforcement agency. So our task is to fight serious crime and terrorism. And one context in which we indeed look at publicly available information, including personal data, is the so-called EU Internet Referral Unit. So that is a unit within Europol's Counterterrorism Center, and there are about 50 colleagues who keep a close eye on social media. When this was introduced back in 2015, there was quite a public outcry, and I think there were also quite some panels here at CPDP on the topic, because the assumption was, okay, here we go, now the EU goes and is introducing an internet censorship unit. So a unit dedicated to monitoring all of us, what we do on social media. So there was a lot of tension, of course, in the room. And as a member of Europol's data protection function, of course, then I also took up that information. And I sat together with my operational colleagues and I explained the concerns in civil society. And we had some exchange on how we would go about that, because at the core of the concern was ultimately freedom of expression, right? So for those of you who are very sensitive, you can still look at this one, because when we look at the internet, we are primarily looking into Islamist extremist terrorism propaganda, which is sometimes very well done, very high quality. So my operational colleagues call that Hollywood-style propaganda, nice music, drone pictures, and so on and so forth. So you may have some views on whether or not that is protected by freedom of expression or freedom of speech. But if you look at the following picture, and for those who are very sensitive might want to look out of the window now, that is what my colleagues are after. This is what we track down on social media. So that is, I think, we can all safely agree, something which is not covered by any freedom of expression or freedom of speech if you advocate this online. Which takes me to the Twitter rules, which in the meantime are X rules. And the point I'm trying to make here is what we are doing at Europol is what each and every one of you could also do if you flip open your smartphone right now. You look for the X rules, you're going to find a page where you can report violations. And then in the past, as Europol, we had to specify what exactly we are after. So we made reference to violence and threats. In the meantime, with the X rules, this has changed a bit, because in the meantime there's more flexibility. So now the X rules say you may share graphic media if it is properly labeled, not prominently displayed, and it is not excessively gory or depicting sexual violence, but explicitly threatening, inciting, glorifying, or expressing desire for violence is not allowed. Okay, here already, let's say on the terms and conditions, you can see what I think all of us are aware, that nowadays X is not what Twitter used to be. So there's much more hatred out there, and that's a matter of concern. But the point I was trying to make here, and that is admittedly a bit social engineering you, is What we are doing at Europol is don't worry about it. What we are doing with your publicly available information, because you and each and everybody could do that. On the picture you see my grandma, and that's really my grandma. So she's not alive anymore, so I can be honest and public about it now, but she became 98 years old, and until her very late days, basically, she remained very interested in what it is we are doing at Europol. I taught her how she can fight the Islamic State online, how she can help with our mission, and she was very active, as you can see here. So there's no threat to her life anymore. So now from a data protection perspective, I can share this with you, and she probably smiles down on us from above. But on the other hand, I'm honest with you, I'm social engineering you. So of course there's a difference between what my grandma does and what we are doing at Europol. And the difference is indeed we are using tools which are way more powerful than what my grandmother had at her disposal. So my grandma maybe reported one of the small dots on the lower left side there of this slide. At Europol, we are not going to waste our time with those little dots. We're going to go after the big dots, because the big dots represent accounts basically which spread Islamist extremist terrorism propaganda on a daily basis and have hundreds, if not thousands, of followers. So while my grandma may report somebody who then also can set up the account in 3 minutes again, we have stopped that. So you can be, if you have a little bit of training, you can have your account up and running again within 3 minutes. So you may ask yourself, why are you making all that effort? But the difference is, if we make sure that those big dots are taken down, those people can also reinstall their accounts, but it will take them months, if not years, to regenerate the number of followers and to have the same impact. So this is how at Europol we use commercial intelligence providers, because for these kind of overviews, you cannot do that alone. You have to rely on data which is out there, and that is mission critical. Now, on the other hand, I told you already, in terms from a legal viewpoint, we rely on that small sentence in the Europol regulation which talks about Europol may directly receive information, including personal data, from publicly available sources, including the internet and public data. So what you see here on the screen now is a very recent excerpt from an opinion of the European Data Protection Supervisor, sharing their view with us on how we can monitor the blockchain. So it's a tool called chain analysis which we are using, and here you can see basically that the EDPS ultimately agrees with our definition, which we have implemented at Europol, that publicly available in very simple terms means everything each and every one of you could get access to, even if you may have to pay a little bit. So we are getting back to my grandma. The logic of the legislator is if Jan's grandma could purchase that to fight serious crime and terrorism, then, for God's sake, also Europol should have that possibility. That's the principle. But then there's a but. And the but is, when we talk publicly available information, there are certain limits. So what you see here is an excerpt on our policy on the use and management of so-called anonymous internet service. So when we browse the internet for operational purposes, of course we have technical means to cover our IP address, because we don't want adversaries, criminals, let's say, to be able to track back that Europol is interested in them. And here again you can see what Europol can do and what we cannot do. So we can monitor publicly available sources, including via commercial intelligence providers, but we cannot, for instance, create legend accounts on a forum where there are administrators who say, well, we are an interest group here. The interest may be sexual abuse of children, for instance, but we only allow members, so first you have to convince us that you are really a member of our interest group. At Europol, we cannot gain access to these kind of forums. That's for national law enforcement authorities, undercover agents to do that. At Europol, we are out of that game. Last point, and that draws a link to what Sharon and also Corbinian said earlier. Where are the boundaries then? So what you see here on the screen is an offer which colleagues from the Counterterrorism Center brought forward to my attention. At some point they said, Jan, we have a very interesting commercial intelligence provider here based in Israel. So I'm not going to put names on that, of course. But do you think it's allowed? Can we do that? So can you look at the terms and conditions? Can we purchase that data from this commercial intelligence provider? And that is from top of my head, so it's not really a quote, but the essence of that file was, if you looked at that commercial intelligence provider based in Israel, it basically said, we will get you any information you need. So we will infiltrate, we will impersonate, we will hack into the system. Whatever it is you need, we will make sure you get it. It costs quite a bit of money, but here we go. So when I studied these terms and conditions, you can imagine that this was the moment when you have to perform as a data protection officer. So that is the job of an internal assurance provider, because I have exactly the same reading as Sharon shared with you earlier. It cannot be correct that European law enforcement authorities, in order to obtain data, depending on what data we are talking about, you may need a judicial warrant, you may need an investigative judge, you may need a prosecutor authorization. So there is a process. It cannot be that all these safeguards we circumvent by simply saying, oh, there's this fabulous commercial intelligence provider from Israel, so we buy all that stuff. Easy. That cannot be correct. So we stopped that one internally from the side of Europol's Data Protection Office. And for the sake of fairness, let me also be very clear, the colleagues, when they read the fine print in the terms and conditions, there was no debate. So it was not like, oh, Jan, you're ruining our game here, and that would have been so nice. Come on, you also have to be flexible. None of that. It was clear. But it's interesting, that's the tension which I think also the other speakers have made already. And then a very final remark, because you may say now, okay, but they, at Europol, they sort out all these things internally. There's Jan Ellermann from the data protection function, independent function, by the way, internal assurance providers. We are with access to all the files. But if they pull him over the line, they can do whatever they want. Not correct. So at Europol, we have a system of multiple layers of external scrutiny, including data protection scrutiny by the European Data Protection Supervisor. I put some muscle here, but let's make him disappear because that's kind of ugly. But the EDPS indeed has quite some muscle power when it comes to Europol, including in the domain of using commercial intelligence. Because whenever we initiate a new processing operation, so say we are considering to purchase a new commercial intelligence provider, that would trigger the need to have a prior consultation of the European Data Protection Supervisor. And then the EDPS can tell us, or in the case of the Israel example, which I just used, no single doubt would have told us, this is neither necessary nor is it proportionate. So you cannot do that, and we advise against it. So that would be a recommendation, or as they put it then, deems necessary that Europol would not purchase this particular offer or provider. We are then, of course, still free because the EDPS is not the Pope, so we can still have a different view. But we would then also have to accept that the EDPS uses enforcement powers. So they would, in all likelihood, if we proceed anyway, they will ban the processing operation. And then the last thing we can do is to challenge the processing ban in court, which in the example I used, we would lose very clearly. So we don't go down that way. But that's all from my side. I'm running out of time, I feel. I'm sorry.
Thank you. No. Thank you so much, Jan. Also for that. And no, I don't need to pull the plug from you, Jan. And there are interesting services. You know, some of you mentioned some tools offered from Israel. I heard, there's this tracking from the cradle to the grave. So individuals, their entire lifespan can be captured and monitored and aggregated and sold. And Judith, I'll turn that off. Judith, over to you for a perspective from an oversight body, and who, among those in Europe who have looked into these topics, you were one of the first, I think, and so very, very interested to hear from you. Thank you.
Thank you, Thorsten, and it's a pleasure to be here. Commercially sourced data usually also qualify as bulk data sets, so I come with another term on the table. Right. I will focus on some investigations and recommendations of the CTIVD with respect to bulk data sets, including those containing commercially sourced data. And in doing so, I will focus on how these recommendations have led to additional safeguards in the Netherlands. Before I do so, I will make a few comments on the Dutch legal framework to put a bit of context to our recommendations for processing bulk data sets. But I will start with saying a few words to introduce my organization. So the CTIVD is an independent oversight body with a special task. We have a legal mandate to keep oversight of the 2 Dutch intelligence and security services. And so this means that we review the lawfulness of all activities performed by these services. And to enable us to do so, we have far-reaching investigative and reporting powers, and in some situations also the power to intervene. For today's purposes, it is important to keep 2 things in mind about the Dutch legal framework: the Dutch Intelligence and Security Act that governs the work of the services. First, the Act does not contain any special or specific rules on commercially sourced data. It only uses the term data, which is defined as special or personal data and other data, and it does not make a distinction between commercially and non-commercially sourced data. And secondly, the Act distinguishes between so-called general and special investigatory powers to collect data. So general powers include the collection of data from open sources, the publicly available data that Jen was also talking about, such as the internet, and through the use of informants. And examples of special powers are the deployment of agents and the power of hacking. Special powers are perceived as more intrusive than general powers, and therefore they come with additional safeguards. But the Dutch services have the power to collect bulk data collections with both general as well as special powers. So consequently, bulk data sets obtained with general powers from open sources and from informants is subject to less safeguards than the processing of bulk data sets obtained through special powers, such as the use of agents and other special powers. Thorsten mentioned already that we have published several review reports on the collection and further processing of bulk data sets. And for today's purpose, I would like to focus on some main findings and recommendations that these reviews have in common. So first, bulk data sets contain large amounts of personal data of organizations or individuals who are not and never will be subject to investigation by the services. And because of these characteristics, we have consistently emphasized that the collection and further processing of these sets constitutes a severe interference of privacy. And it is therefore crucial that the fundamental rights of those involved, especially those who are not under investigation of the services, are sufficiently protected. Secondly, the Act, besides one exception, does not have a specific regime for the processing of bulk data sets. So as a result, the review of the lawfulness of processing bulk data sets can only be assessed against the general legal requirements that apply to all data processing. For instance, data must be processed exclusively for a specific purpose and only in as far as necessary for the services to perform their legal tasks. Data processing must also, in accordance with the law and with due care. And so these requirements imply, amongst other things, that measures should be taken to limit access to data on a need-to-know basis. But although these general legal requirements form a good starting point for a legal assessment, we found that it does not offer a sound legal framework for the processing of bulk data sets, and also not for properly reviewing the lawfulness of those processing. And for this reason, we have recommended to turn to a more inclusive regime for the processing of bulk data sets that does sufficient justice to the protection of fundamental rights and also the operational value of bulk data sets for services. And in doing so, we have also made it clear that such legal regime should be based on the principle of what we call bulk is bulk. And what we mean by this is that adequate safeguards should be in place for the processing of any bulk data set, regardless through which power the services have obtained a data set or gained access to it. Well, the ministers have endorsed this approach, and there will be a new legal regime for the processing of bulk data sets be implemented in the upcoming amendment of the Dutch Intelligence and Security Act. But in anticipation of that upcoming amendment, the ministers have already set additional rules for the processing of bulk data sets in a temporary regulation, and that entered into force in November 2020. And that regulation addresses already several concerns and recommendations of the CTIVD, and I will give a few examples. As previously indicated, general powers such as the collection of open sources via the so-called publicly available data were initially seen as not very intrusive, but I think that Jen explained very clearly that it's no longer the case, because today's publicly available data and what you can do with it by using automated software tools is very different from the traditional open sources and tools such as newspapers, which was also on the picture of Jen's grandma, and also web browsers. So these developments have increased the risk for infringements significantly. And for this reason, we have recommended that it must be foreseeable for citizens that the services can also collect and further process bulk data sets through the use of general powers. And in view of this recommendation, the temporary regulation now explicitly stipulates that it applies to all data sets, thus also for those obtained by general powers. And the regulation is also based on two important principles which are also in line with the bulk of bulk approach. First, the method of collection is not normative to assess the extent to which the right to privacy will be restricted when the bulk data set is further processed. And secondly, the greater the restriction to fundamental rights during the process of further data processing, the more safeguards should be in place. And I will give a few examples of what this means in practice. After obtaining a new bulk data set, the services must always first assess the extent to which processing of the bulk data set will restrict the right to privacy. In doing so, they consider the extent to which a bulk data set provides insight into certain aspects of private life. To this end, they evaluate the sensitivity of the data in the data set. So they look at various categories of data which increase the sensitivity, such as identifiable data or location data. And based upon this assessment, the minister has to ultimately approve under which access regime the data set will be further processed. So standard, limited, and strictly limited are the access regimes in place. And this access regime determines who within the services have access to the data and under what conditions. The regulation also includes obligations for the services to notify the CTIVD. So, for instance, we must be notified every time the minister has decided upon an access regime. Finally, there are guidelines to periodically assessing the necessity of retaining the data sets. Data sets collected through general powers must be reassessed within 1, 2, or 3 years, depending on the access regime. And for bulk data sets collected through special powers, there is a new legal regime that applies. About a year ago, a new temporary act has come into force, and based upon that law, bulk data sets obtained through special powers must be destroyed within 18 months. That is not new, but what is new is that the services may ask from the minister permission to retain a bulk data set for an additional 12 months. If there is an urgent need to do so for national security purposes. And to get a permission, they need to demonstrate that such a retention is necessary and proportionate, and also meet a whole series of other legal criteria, for instance, the obligation to ensure data minimization. And if the minister approves such a retention, we review whether that permission was given lawfully. And to exercise this part of the law, we have also been given binding powers. And these binding powers allow us not only to declare the retention of a bulk data set unlawful, but also to order the destruction of unlawfully retained data sets. So to conclude, in recent years, several additional safeguards have been introduced with respect to the processing of bulk data sets, including those containing commercially sourced data. We are currently in the process of reviewing the Intelligence and Security Act in the Netherlands. The ministers have already endorsed this bulk is bulk approach, but consultations about other aspects continue, and this offers also the opportunity to consider the need for a special legal regime for commercially sourced data in the Dutch law. Thank you.
Super. Thank you so much, Judith. Shedding some light on how your oversight body has fared. And I have a number of questions to the panelists, but I don't think it would be fair, because I think I want to open the floor and ask you to ask questions if you have them. And if you do, I would like to ask you to please briefly identify yourself and point to the person to whom you would like the answer to be posed. So.
Hello everyone, my name is Matthias Rodnik. I also work in Europol's data protection function. Thanks a lot for the very interesting panel. I have two questions. So one question is about, I was reading an article about using target advertising for personal surveillance. It was from the University of Washington Engineering School, and I wanted to ask, especially the US colleagues, what she thinks about it. And what I understood also, from a technical perspective, very often the mobile advertising ID is used for it. So basically every phone has like a mobile advertising ID, you can read it out and you can track on it. It's similar to cookie tracking. And this is also used in signal intelligence. And I would be interested if you have any insights about that. And then my second question would be related to the bulk access of data. What is your opinion on that? Because would you say, is it balanced now, let's say the amendments, or is it like, I would be very interested to get your personal opinion about it. Thank you.
Thank you. Before you go, let me see if there's one more question perhaps that we could collect in the interest of time. It would be nice if you do have another question. Okay, so Sharon, please.
There was a question.
Oh, there was a question? There was a question.
Yeah, in the front.
Right in front of me, apologies. Didn't see that.
Hi, thank you for the panel. My name is Ronit Wilmersdorfer. I'm with Volt Europe. And I was just wondering, because this is advertising data, so this is data that usually commercial actors use to display content to users. And I was just wondering if there's any practices within security services to actually use data in that way to, I don't know, either get in touch with people or otherwise try and influence them. Maybe you can say something about that. I'm just curious. Thank you.
Thank you.
Okay, so to the first part of the first question. So What I was discussing regards, government access to data from data brokers, but your question with the targeted advertising for surveillance, I think goes to surveillance really by private companies. And in the US, we still lack a comprehensive federal commercial privacy law, sadly, and sorely need that. There was, with regard to data brokers, there have been some efforts as well. There was an effort by our CFPB, Consumer Financial Protection Board, which is another one of the independent agencies under attack in my country. And they had put out in December a notice of proposed rulemaking to address some of these issues. It was going to, under the Fair Credit Reporting Act, limit the sale of personally identifiable information and social security numbers and so forth. But just a couple of weeks ago, that was canceled by the current administration, so that effort is not currently happening. There are still some conversations in Congress about moving forward with further regulation of data brokers in the private sector, but so far it's been very limited. We had one law, it's called Daniel's Law, which applies to judges and the sale of their personal information following an awful tragedy with a judge in New Jersey. But sadly, we're not seeing right now anything that I can say is imminent in that space.
Thank you. Judith?
Yes, I would like to say two things about it. I think it has been improved, but much more needs to be done. First, I haven't talked about the fact that services can obtain data which were previously leaked or hacked, for instance. And so the services are also required to ensure the reliability of data, and so where it comes from. And in one of our reports, report 74 on automated OSINT, we have made it clear that in our view, the services don't know sufficiently the source of the data. And so we have recommended that they also should develop a policy on that. And the other example I would like to give is that the Dutch Act acknowledged that data exchange is possible in the context of cooperation with other bodies. And they have specific rules on the cooperation between services and foreign services, and also between the services and government bodies, but they don't have specific rules for the cooperation between services and private sector entities. And we have also recommended actually that there should also be a special regime for that cooperation.
Any of you? Yeah.
Yeah, maybe just to briefly respond to the advertisement intelligence question here and whether law enforcement uses that. So, I mean, the business model of Facebook and many others is that the platforms basically register what users are interested in. And then basically they sell this information to companies in order to enable the companies to place their ads or to target their ads to people who might really be interested in those products and in this stuff. So as law enforcement, we don't do that. So we don't communicate, we don't buy intelligence in order to communicate to certain target audiences. We also don't influence them. I think your question makes sense because the famous example of Cambridge Analytica ultimately shows that you can use that intelligence in order to influence in all possible ways. So I see your point that also law enforcement might have an interest to influence society, but clearly that would be out of mandate for Europol, and we would also as a data protection function be very concerned if we see any such trends or developments or even thoughts. But on the other hand, I think it's also a reality that when Facebook and all others collect all that data, that certain commercial intelligence providers might buy it and tailor services which ultimately are of interest again to law enforcement. And that indeed happens. So I told you earlier how we use also commercial intelligence providers to track down Islamist extremist propaganda in the most effective way. And that's not the only use case. So at Europol, currently we use around 18, 20 different commercial intelligence providers. Another very evident example would be if you think about Dun & Bradstreet. So I don't know if many of you know that service, but Dun & Bradstreet is basically a commercial intelligence provider which allows you to understand who owns which property worldwide. So if you have a company name, you can basically query Dun & Bradstreet and you will find out basically which kind of assets that company has. That, of course, can be of interest in all kinds of investigations to understand if you have a certain name or a company or whatsoever, okay, what is the setting of that?
Corbina.
Yeah, maybe just to add one thing to the question of how can these ads actually also be used for purposes of security services. One scenario that would be thinkable, I mean, I also think that it's more relevant like to extract the data from this kind of interactions, but what is imaginable is to use it to play out spyware then, because since I think you cannot display an ad just to one ID, but since you have many information you can narrow down very, very precisely like the location where the ad is shown and to which target group and whatsoever. So you can actually do it quite targeted. And what is thinkable or imaginable? I mean, I don't have any, I don't know any cases where this was done, but this would be a possible use case for this to actually use it to play out spyware with infected ads and links behind it.
I feared that moment would come, and it came far earlier that I wanted it, because we had questions prepared. You know, it's so nice that we had this perspective from Europol. I've, of course, extended the invitation to other security services, and some of them can speak publicly, some cannot. And we've come across in our comparative studies some interesting questions about what oversight bodies can report, what is classified and not. And if you're interested in this topic, watch out for further publications. My time is now to thank all of the audience, Jan, Sharon, Judith, Corbinian, for a topic that I think deserves far more scrutiny even than afterwards today, and for you to show up and being here and pose so many questions. So thanks a lot and have a good day.